Good morning, Chairman, panel members, ladies and gentlemen. Before commencing my opening remarks, I should like to express thanks to those members of the inquiry staff, research teams and legal teams who have worked hard to prepare for this module of evidence. The topic of child migration to Australia is one that has generated a considerable amount of controversy in the United Kingdom and in Australia for more than 20 years. It was brought to the attention of the wider public by the work of Dr. Margaret Humphreys in particular, and by her book, Empty Cradles, One Woman's Fight to Uncover Britain's Most Shameful Secret, which was published in 1994. Extracts from that book can be found in the inquiry bundle of evidence at pages AUS 1001 through to 1019, for those of you who require to read it in the bundle. Since then, numerous film and television programs and newspaper articles have dealt with the experiences of many of those who went to Australia as children under what, for convenience, can be described as the child migrant scheme, although, as will become apparent, there were many individual schemes which made up the overall process. These schemes have been examined by parliamentary bodies in both Australia and the United Kingdom. In November 1996, the Western Australian Legislative Assembly considered them in its interim report. The United Kingdom House of Commons Select Committee on Health did so in its third report published on the 27th of July 1998, as did the Australian Senate Committee Inquiry into Child Migration in a report prepared following hearings held in 2001. All three reports and many other publications which have referred to various aspects of this process have provided much useful material for the inquiry, and I wish to take this opportunity to acknowledge the invaluable help they have provided. However, we believe that this inquiry is the first judicial inquiry in any part of the United Kingdom to consider the issue of child migration to Australia. As the Chairman has indicated, the relevance of child migration to the work of this inquiry became apparent when the inquiry published its existence in Australia through the Australian media in 2012 and 2013. The inquiry did this because it anticipated that there may be some individuals now living in Australia who had been in those institutions which fall within the inquiry's terms of reference and who might wish to approach the inquiry. The inquiry received over 60 applications from former child migrants who now live in Australia and who were sent there in the aftermath of the Second World War from institutions in Northern Ireland which fall within our terms of reference. From the initial contacts of the applicants with the inquiry, it became obvious that there were several aspects of their experiences that required investigation. Firstly, their allegations of abuse, which they say they suffered in residential institutions in Northern Ireland before they went to Australia. Secondly, how and why these children were selected to go to Australia, because many alleged that the process was itself abusive. Several are bitterly critical of the institutions for sending them to Australia and of the Northern Ireland and United Kingdom governments for permitting and facilitating their being sent there. They also complain of the effect that being sent has had on their lives, not least because they allege they were subjected to serious forms of abuse in the institutions to which they were sent in Australia. As the inquiry will hear, many lost all contact with their parents and siblings, although after many years and much effort, some were able to re-establish some contact with the relatives. For others, it was too late, because their parent had died, or when they were able to trace their parent or family members, the reunions were not successful. Their complaints also extend to other matters, such as not being able to obtain birth certificates, or discovering that their names or dates of birth had been altered, things which created major difficulties for them in later life when they had to prove their identity for official purposes. The inquiry will hear personally from some witnesses of the impacts of child migration on their lives, and it will also learn more from the witness statements which I will read. Dr. Humphreys will later today speak about the impact on those with whom she and the Child Migrant Trust have been involved. The inquiry also received a document entitled Report on the Impacts and Outcomes of Child Migration Experienced by Former Child Migrants from Northern Ireland, which was prepared by Dr. Philippa White, who is a director of Tuart Place, and can be found in the bundle at AUS 6056 to 6057. However, I think a good example of what you will hear can be summed up in the words of HIA 325. And this can be found at page AUS 10743, and I would ask that that page be called up, please. That's 10743. This gentleman was seen by the inquiry legal team in Perth last year, and if we look at paragraph 30 of his statement, he told them, "My life in institutions has had a profound impact on me. I've always wondered what it would have been like to have had a family, a mother and a father, and brothers and sisters. I never got the chance to find out because I was sent to Australia. We were exported to Australia like little baby convicts. It is hard to understand why they did it. I know the theory, to populate Australia. I still cannot get over the fact that I was taken away from a family I never got the chance to know. I was treated like an object, taken from one place to another. I find it very hard to show affection to my children when they were young. I've improved as the years have gone on. I have a nightmare every night of my life. I relive my past, and I am happy when daylight comes." HIA 325 was born in 1938. He was 75 when these words were spoken. Sadly, he died before he was able to sign his statement and to see this inquiry consider his account and that of the other child migrants. In order to obtain evidence such as that of HIA 324 and others relating to these matters, the inquiry has sent teams to Australia on 2 occasions. These teams recorded witness statements from those who had contacted the inquiry and wished such statements to form part of the statutory inquiry. They also afforded those who wished to do so the opportunity to describe their experiences to members of the Acknowledgement Forum in the same way as applicants have done in Northern Ireland and elsewhere. The first team spent almost a month in Australia in September and October 2013, and the second returned for a further month from early June to early July this year. It is clear from the witness statements provided to the inquiry that a great many of the applicants say that they experienced severe physical, sexual and emotional abuse after they arrived in Australia. But as you have already explained, Mr. Chairman, this inquiry has no power to investigate those allegations. It is nonetheless concerned with the actions of institutions in Northern Ireland and their role in selecting and sending children from Northern Ireland to Australia. The children sent were mostly under the age of 12. The majority were under 8, and some were as young as 5. As the inquiry will hear in due course, although a few of whom it has been possible to identify were sent to Australia, a few of those were sent there by county welfare committees or by voluntary organisations such as Dr. Bernardo's or Manor House Children's Home in Lisburn, the numbers sent by these institutions were small. The great majority of those with whom the inquiry will be concerned came from 4 homes run by the Sisters of Nazareth in Northern Ireland. Many came from Termanbacca and Nazareth House in Bishop Street, Derry, institutions about which the inquiry has already heard evidence. The remainder were sent from Nazareth House and Nazareth Lodge homes in Belfast. It has proved extremely difficult to obtain precise figures as to how many children from institutions in Northern Ireland, falling within the inquiry's terms of reference, were sent to Australia, because such records as were kept are not complete. Nevertheless, from the information provided to the inquiry by the Sisters of Nazareth, and from the inquiry's own searches in the Public Records Office of Northern Ireland, it appears that approximately 131 children within our terms of reference may have been sent to Australia. The Sisters of Nazareth sent 111 children, and it appears that another 26 may have been sent by training schools, local authorities, or voluntary homes. However, this figure of 26 includes a number of children who were put forward for emigration, but as the records are incomplete, it may be the case that some of these did not actually go. The inquiry can only identify 20 of the 26 as going with any reasonable degree of certainty, making a total of 131, 111 from the Sisters of Nazareth and 20 others. I turn now to say something about the historical background to this module of the inquiry, and it is appropriate to state that in preparation of this section, the inquiry has been helped greatly by the work carried out by Dr. Anne Mary McVeigh, PhD, of the Public Record Office of Northern Ireland. Dr. McVeigh prepared a thesis on the topic, A History of the Child and Juvenile Migration Schemes to Australia, for which she was awarded a doctorate by Queen's University in 1995. The thesis is found in the bundle at pages AUS 1020 through to 1353. Dr. McVeigh will speak to the inquiry later today, and in this portion of my opening, I will simply give a brief account of her evidence. It is now well recognised that the practice of sending young, unaccompanied minors abroad has a long and varied history. Indeed, the first contingent of young migrants was sent to Virginia in 1619. Throughout the remainder of the 17th and during the 18th and 19th centuries, child migration to various colonies and to the dominions within the British Empire and Commonwealth was widespread. Although various acts of the United Kingdom Parliament were passed which permitted this policy, the actual migration was arranged by statutory, voluntary, or religious organisations, which made all the necessary arrangements. In later years, subsidies were paid both by the British government and by the authorities in the countries to which the children were sent. Throughout the 19th century, large numbers of young children were assisted to emigrate, mostly to Canada, and Canada remained the favourite destination for child migrants until this practice was brought to an end by the Canadian government in the 1920s. Australia began to become a more popular destination for child migrants as emigration to Canada became less popular. Although some children did go to other countries, such as New Zealand, South Africa, and what was southern Rhodesia, now Zimbabwe. In the early part of the 20th century, a number of schemes for child migration were created by voluntary societies which flourished at the time. The Big Brother movement was launched in London in July 1925, and the first consignment of Little Brothers arrived in Australia in 1927. The Big Brother movement was essentially an assisted passage scheme for boys aged from 16 to 17 and a half. It guaranteed to find employment and accommodation for each young man and to be his legal guardian until the age of 21. It provided a surrogate big brother, someone who would keep a fraternal eye on the youngster. Between 1925 and 1931, it introduced 1,926 boys into Australia until its activities were halted by the Depression. The scheme re-established itself in the late 1930s, but its efforts were interrupted by the onset of the Second World War. After the war, it was once again re-established and sent an average of 200 boys a year from 1947 right through until the 1970s. The Fairbridge Society was named in honour of its founder, Kingsley Fairbridge. It sent children to be brought up in farm schools, where they would be taught to be farmers and farmers' wives. Kingsley Fairbridge bought a small farm near Perth, Western Australia, and the first party of boys arrived in January 1913. Throughout the 1920s and 1930s, the farm school continued to grow, and a second farm school was opened in New South Wales. By the outbreak of the Second World War, the Society had sent 1,202 children to Australia. When migration resumed in 1947, approximately 600 more unaccompanied child migrants passed through Fairbridge. The Society was a non-denominational organisation, and such was its reputation that many other organisations, including local authorities, church-based associations, and various children's societies, sent children in their care to be brought up on Fairbridge farms in Australia. One of these societies was Dr. Bernardo's. In due course, it opened several more homes and training schools in Australia, and by 1960 there were 9 Bernardo's centres in Australia, all in New South Wales. From 1921 approximately, 3,000 children emigrated to Australia under Dr. Bernardo's auspices, 500 of whom left Britain after 1947. Bernardo sent the last group of migrant children to be sent to Australia, a party of 9, in 1967. 7 children who were born in Northern Ireland did emigrate to Australia from Bernardo's homes, and if we could call up the pages at pages AUS 2341, please. We will see a table that has been provided by Bernardo's outlining the reasons for the migration of each of these 7 children. You will see that in accordance with our redaction policy, the names and dates of birth of those children have been redacted. And in respect of the first child, he asked to emigrate as he had an aunt in Queensland, and permission was given by his mother. The second child asked to be considered for migration as both parents were dead, and he was unable to locate grandparents or trace any relative, but an uncle gave his consent. That child was aged 11, the first child was aged 15. The third child asked to be considered for migration as some of his friends had gone and told him how much they liked it. His father gave consent, and you will see here that approval for migration was received from the Minister of Home Affairs at Stormont under Section 111, subsection 5 of the Children and Young Persons Act, Northern Ireland, 1950. That child was aged 13. I will return to discuss the statutory requirements and implications later. If we could scroll on to the next page. The fourth child was aged 17. Her mother and grandparents had emigrated to Canada, and she asked to go to Australia to join her boyfriend and foster brother who were living there. Her mother, living in Canada, gave her consent. The next child was aged 14, and the father wanted to emigrate as he was aged 40, and it was now or never for him. As a single father, he couldn't make arrangements for his children, and he asked whether they could join an official Bernardo sailing party. The next 2 children form part of the same family, and you will see that it was necessary to get a court ruling on the jurisdiction and the need for both parents to give consent. And if we scroll down to the following page, you will see that the last child of that family was only aged 5, and it was necessary to get permission from the High Court of Justice in Northern Ireland, special permission for that child to migrate with his siblings due to his age. None of these children could technically be said to be part of the child migrant scheme that this inquiry will be concerned with. And as we shall see, the Roman Catholic Church was also closely involved in arranging for child migrants to go to Australia, mostly after the Second World War. Earlier, I said that various Acts of Parliament permitted the operation of the policy of child migration. I now wish to say something more about the legislation which governed this area. During the 19th and earlier 20th centuries, a number of acts were passed by the United Kingdom Parliament which made provision for the emigration of children. The principal legislative provision with which the inquiry will be concerned was the Empire Settlement Act of 1922. This was replaced by the Empire Settlement Act of 1937, which in turn was succeeded by the Commonwealth Settlement Act 1967, and these three acts are properly cited as the Commonwealth Settlement Acts 1922 to 1967. Could we please pull up 0002 AUS, please? And if we could highlight the bottom half of that page. This is section 1.1 of the 1922 Act, and it reads, "It shall be lawful for the Secretary of State, in association with the government of His Majesty's dominions, or with public authorities or private organisations, either in the United Kingdom or in any part of such dominions, to formulate and cooperate in carrying out agreed schemes for affording joint assistance to suitable persons in the United Kingdom who intend to settle in any part of His Majesty's overseas dominions." The Act and its successors did not specifically empower voluntary organisations or anyone else to send children in their care abroad. However, if the Secretary of State agreed that a child migration scheme, whether set up by a voluntary organisation or any other body, fell within the terms of the Act, public funding could be provided to subsidise the cost of the scheme. The 1922 Act was time limited, and the scheme was therefore extended by the Acts in 1937, 1952, 1962 and 1967, and lapsed on the 31st of May 1972. Other statutes gave the Secretary of State or responsible minister power to consent to the emigration of an orphan or deserted child where certain formalities were complied with. In the rest of the United Kingdom, the relevant legislation was Section 84.5 of the Westminster Children and Young Persons Act 1933, which gave the Secretary of State power to authorise arrangements for the emigration of any child in the care of a fit person, if it appeared to him that it would be for the benefit of the child. The Secretary of State had to consent to the emigration and was required to be satisfied that the child consented and that his parents had been consulted, or that it was not practicable for the parents to be consulted. The Act also provided, in paragraph 7 of Schedule 4, that managers of an approved school had the power to arrange for the emigration of a child in their care with the written consent of both the child and the Secretary of State. Prior to the enactment of the Children and Young Persons Act Northern Ireland 1950, the relevant statutory provisions in Northern Ireland were Section 21.6 and Section 70 of the Children Act 1908. If we could call up page HIA 098, please. And highlight Section 21.6, which is at the top of the page there. We can see that this section allowed the Secretary of State to empower someone to whose care a child or young person had been committed by a court to procure the emigration of that child where it appeared to the Secretary of State that this would be for the benefit of the child or young person. If we then go to HIA 118, please. Section 70 of the 1908 Children Act provided for the apprenticeship or disposal by emigration of any youthful offender or child detained or out on licence from a certified school by the managers of the school as if they were the parents of the child, provided that the consent of the Secretary of State was given, where the disposal was to be by way of emigration. This power was availed of on a number of occasions by the Ministry of Home Affairs in Northern Ireland after partition. Section 111, subsection 5 of the Children and Young Persons Act, Northern Ireland, 1950, which can be found at HIA 245 and 246. This section enacted a similar provision to the 1933 Westminster Statute for those children committed to the care of a fit person, which could be a voluntary home, as we have seen already in the list given by Bernardo's, where consent was sought from the Ministry in relation to a child committed to its care. Schedule 4, paragraph 7 of the 1950 Act, which can be found at HIA 276, empowered the managers of a training school to arrange the emigration of a child in its care with his written consent and that of the ministry. In Northern Ireland, it was the consent of the Minister of Home Affairs that was required, not that of the Secretary of State, although, as we shall see, little use was made of this provision in Northern Ireland. It is necessary to understand something about how and why such schemes came into existence by looking at the social context in which they operated. When I opened this inquiry in January, I did refer to the social context in relation to the issue of understanding how children came to be abused in residential care, and some of the socio-economic matters I spoke about then are relevant to this module also. Again, much of the following is taken from the statement provided to the inquiry by Dr. McVeigh, who describes the rationale behind the concept of child and juvenile migration. Essentially, the arguments of those who supported such schemes embraced both concern for the child as well as concern for country or community. An important consideration for many societies of all religious denominations was the religious and moral welfare of the young person. There was a desire to safeguard a child's religious and moral well-being by removing him from the danger to which it was felt that that child would be exposed if it were to remain either in its own unsatisfactory home or in an institution. There was also a belief that the British Isles were overpopulated, whereas the colonies were underpopulated. A similar but separate argument was that there was a need to build up and maintain the empire and to ensure that the predominant population of the empire was of white, common British stock. The most enduring argument in favour of such schemes was a financial one. Those youngsters who were selected and sent to the colonies would have a chance to better themselves, and by their removal, more room would be made available in overcrowded workhouses, orphanages, and homes for other children in need. Therefore, the fare to Australia would be money well spent. All the major child and juvenile migration agencies used some variant of this economic argument. At its simplest, it was reckoned that it was cheaper to send a child abroad than to keep it for several years in a workhouse. In later years, this argument was refined by putting emphasis on the benefits both to the child and to the colonies of child migration. The child or youth, otherwise unprovided for, should be sent to the colonies where he or she could find farm or domestic work, thereby relieving unemployment at home, whilst increasing the labour force in the receiving country. A further consideration was the belief that sending children to a healthy outdoor life in the fresh air and sunshine of Australia, far away from the slums, from evil influences and from institutional life, would do more for a poor child than all the charity offered at home. This was expressed by Arthur Lawley in his epilogue to the autobiography of Kingsley Fairbridge in 1934, when he said that children could become strong and sturdy and efficient citizens able to play their part in developing the vast resources of Australia. Some people considered the risk of drifting into the wrong religion even more damaging. Most religious denominations had their own homes, each replicating the work of homes of other religious denominations. Each, however, jealously guarded its own sphere, and the inquiry will hear great emphasis was placed by many, and by the Roman Catholic Church in particular, on the need for children who migrated to be brought up in what was regarded as the correct religion. In the 1920s, the Australian Commonwealth Government, that is central government, and state governments offered grants to support assisted passages. But by 1930, as we were told in the Australian Yearbook of 1932, quoted by Dr. McVeigh, those concessions were limited to boys for farm work, young women for household employment, and to nominees, mainly wives and children of husbands in Australia. These concessions were revoked in 1932, and although assisted migration resumed in 1938, it was curtailed due to the approaching hostilities, and assisted passages were not reintroduced until 1947. Child migration was, however, the subject of expressions of concern, both about the rationale for the schemes and about their operation. At the end of the Second World War, the British government set up a committee chaired by Miss Myra Curtis, CBE, which reported in 1946. The report of the Chair Children Committee, or Curtis Committee, considered the various options available for care of children in need in Britain. And although this was a report primarily concerned with the British childcare system, the Curtis Committee also considered the matter of child migration. Given the many difficulties and experiences which the inquiry will hear about from applicants, which they say they experienced, the following passage from the Curtis Committee report, which is quoted by Dr. McVeigh, is particularly noteworthy. Could we please put up page AUS 0162?